My Lord, we submit that the legal threshold required while arresting a suspect is lower than the legal threshold required for the prosecution to meet in order to be granted the orders which the trial court erroneously did.
And the legal threshold?
The legal threshold
lower?
In arresting as compared to the threshold that is required of the prosecution to be granted extension for detaining an accused or a suspect prior to being charged.
So let's call that, for ease of reference, pre-charge detention.
Yes, my Lord.
Okay.
In that case, then, the court went into error while interpreting that requirement by the finding that that threshold was met. We submit it was not met. My Lord, support that we have filed the case of Michael Oyamo and others. It's part of the authorities in the fullness of time. I'll invite my Lordship to read page 5, paragraph 23 of that particular ruling, where that issue was succinctly explained.
All right.
There is also the case of R versus Nuseiba Osman. It's part of the list of authorities which we have filed. The relevant section, my Lord, is page 6, paragraph 3. We close by saying that in the ruling, it is nowhere demonstrated that the court invited itself as to whether that threshold was met. My Lord, allowing pre-trial detention takes away. Sorry, my Lord.
Pre-charge.
Pre-charge, yes, no, pre-charge, sorry. Pre-charge detention takes away the fundamental right of the suspect, which is protected by Article 25 of the Constitution. My Lord, this right is one of the only 4 which cannot be limited. But it could not have been a coincidence that Article 50 therefore protected that particular right, which by the decision of the trial court, that right has been taken away without meeting the threshold that the law provides. My Lord, the historical development of criminal justice in Kenya is known. It is, in fact, the basis upon which that Article 49 was informed. It is aimed at protecting the rights of arrested persons prior to their arraignment and charge. And my Lord, to support that submission, we rely on the case of Kenneth Omondi Ocheng and 37 others versus the Republic. That is also, I've noticed, my Lord, that that case is not among the list that we have done, but we will equally avail it immediately. And lastly, my Lord, in conclusion, we submitted that the court, in interpreting the basis of the decision it made, went into grave error. Which we ask this honorable court to correct and protect that which the law also protects. We urge your lordship to allow this application and release the applicant and release the
Mr. Sigay, what at this stage the applicant is interested in is prayer B, correct?
Yes, my lord, that is where I was heading to.
Okay.
That we ask that this court at this point do allow the application and grant prayer 2 with such terms as the court may deem appropriate in the circumstances. My lord, the applicant in his affidavit has undertaken to comply with such conditions as you may grant. We therefore pray that even in the absence of a written reply by the prosecution, this application should be deemed not to have been opposed. I therefore pray that you allow it, and I thank you, my lord. Thank you.
Mr. Skay, just a question for you.
Yes, my lord.
Before Mr. Arumi speaks.
Yes.
To the extent that the state says that it's apprehensive that the applicant may continue making utterances which it deems to be capable of inciting the public and or addressing members of the public in the same regard to which the court, the state considers unlawful. Is the applicant binding himself not to do so, at least during the period of investigation and before the charge?
Thank you very much, my lord. As I have said, the applicant has undertaken in his own affidavit, which is in the supporting the application, he equally undertakes to keep peace and comply to the letter of the conditions that my lordship shall give.
Thank you, Mr. Sigay.
Thank you, Lord.
Mr. Karuri?
Much obliged, my lord. My lord, we oppose this application by the applicant. My lord, on the following grounds. Number one, my lord, the applicant should have brought an appeal instead of a revision in this matter. My lord, under section 362 of the Criminal Procedure Code, this court has the powers to call for and examine the record of any criminal proceedings for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding. It is our submission, my lord, that Honorable Carlo, Chief Magistrate, in his ruling, was right in denying the applicant bail in view of the compelling reasons which we demonstrated before him. That there was immense public interest in this matter. And in the interest of national security and public safety, the applicant should be detained to enable police to conclude their investigation. My lord, we complied with the provisions of the Constitution, Article 49(1) G and H, because we informed the applicant the reason for his continued detention. And we demonstrated compelling reasons as provided for in the law.
And what is the reason for its continued detention?
My lord, the main reason for the continued detention is the immense influence the applicant wields on the ground as Member of Parliament for Kapsaret that would make the police be unable to record statements from witnesses who were at the scene. Much better. My lord, we are still conducting investigations even today, my lord. And we are not yet ready to present any charge until we conclude investigations. My Lord, the submission by counsel that we should have preferred a holding charge is not tenable because the same will not be accurate in its particulars as the investigations are still ongoing. And would offend the very foundational principle of certainty of a charge. As provided for under section 134 of the Criminal Procedure Code.
Let's proceed, Mr. Karuri. It seems Mr. Karuri has been frozen out. Mr. Karuri, can you hear us? Oh, you're back, okay. So very clearly, the internet did not like your last point. Okay. Please proceed.
My Lord, in the bail and bond policy, paragraph 3, 1E.
3-1E.
Yes, my Lord.
Okay.
We submit that the court correctly applied the principles in this policy that bail determination must balance the rights of the applicant and the interests of justice. My Lord, we demonstrated that the applicant would undermine the integrity of the criminal justice system by interfering with witnesses, and it was therefore necessary to deny him bond at this moment. My Lord, the interests of justice demand the protection of the investigation process against probable hindrance by would-be accused persons.
The interests of justice demand
the protection of the investigation process against probable hindrance by would-be accused persons. My Lord, my final submission is that if my Lord will be persuaded to grant bail, would pray that as part of the conditions of the bail, default to by the applicant in paragraph 35 in his affidavit, that he is willing to comply with any orders issued by the court. Would be that the court cautions the applicant not to make any insightful utterances. And my lord, I'm happy that you brought up the issue before I commence my submissions that the applicant should bind himself not to make any further utterances. I'm much obliged, my lord. Thank you.
Mr. Harvey, before you speak, I have a question for Mr. Karuri, and then I have a question for Mr. Sudi. I will begin with Mr. Sudi. Mr. Sudi, can you hear me? You can hear me, Mr. Sudi?
I hear you.
Okay. The question for you is, now we are at even pre-arraignment stage, and so I take this to be more of a inquisitorial process. So I wanted to find out from you, as you know, the Constitution grants you the freedom of expression, freedom of association, and so forth. But sometimes people can choose to forego some of those rights in view of other welfare-enhancing considerations. So the question for you would be, you are roughly aware of what the state is complaining about, the statements you made. Am I right?
All right.
Are you willing not to make those kinds of remarks, whether they are insightful or not? Are you willing to bind yourself not to make them, at least until you are charged?
Yes.
You are?
Yes.
Thank you. Mr. Karuri, a question for you. So, you've relied very heavily on the influence of the applicant. And I'm just wondering, quite objectively, is the influence of the applicant any less when he is at Nakuru Central Police Station? Does it drastically go down in threat that now he is being incarcerated here?
My lord, in my view, it does. The fact that he's at the police station,
Yes.
has greatly cooled down the temperatures on the ground. This is my objective, my lord.
keeping within time, and now we have Mr. Harvey.
My Lord, I'll make it short.
Yes.
My Lord, it has been submitted by my learned colleague, Mr. Daniel Karori, that the applicant ought to have lodged an appeal. My Lord, an appeal would not have been the appropriate reprieve for two reasons. One,
Yes.
we don't have a criminal case yet. We don't have a criminal case yet because the applicant has not been charged. And my
Yes.
Lord, even if the applicant had been charged, it is strike law. The latest decision being won by the Supreme Court a week ago, that no appeal lies against an interlocutory decision in a criminal matter. It is strike law. My Lord, it was submitted by my learned colleague that there was compliance with Article 49, Sub-Article 1, Paragraph G, to the extent that the applicant was informed of the reason for the detention continuing. My Lord, it is indeed true that he was informed. What was the information given to him? That we cannot release you for the reason that as the honorable member for Kapsaret, you are so influential that we cannot investigate this matter unless you are held pending charge. My Lord, there are two birds. One is an eagle with a very big wingspan. It can fly for 100 kilometers without perching. There is also another bird called a quail. Where I come from, we call it isindu. It cannot fly for over 50 meters. You cannot tell the eagle that thou shalt not fly because you have a big wingspan, like the quail. Honorable Sudi will continue being the member for Kapsaret until 2022 unless something else happens. So if that be the reason, then that is not a good reason for detention. Lord, lastly, we've been told it is in the public interest and the interest of national security to continue holding the honorable member of the National Assembly for Kapsaret. My Lord, it has been said by courts time without number that where there is a contest between national security and a right in the Bill of Rights, the right must of necessity prevail. That is why here we have madmen outside there making noise. It is their right to be mad. Lord, on the issue of public interest, again, it has been said time without number that public interest is best served by upholding the law. My Lord, we beseech you to uphold the law, This is a matter where the honorable member for Kapsaret should not even be asked to post cash bail. He should be released on his word to keep the peace. We humbly beseech your lordship to release the honorable member of Kapsaret so that he may glide for 200 kilometers to his people. Let the quails fly 50 meters, let the eagle glide for 200 kilometers. That is our plea, my lord.
Thank you, Mr. Harvey. Let me thank all the council for really keeping it very short and for keeping it very civil. I must appreciate that. This is the way we knew the practice of law a long time ago. And Mr. President, you have a big job to return this kind of practice.
Thank you, Lord.
I will, it's now 11:10. Allow me to take about 2 hours to consider the applications and the submissions and the representations before the court. And then in about 2 hours, I'm not promising the ruling will be ready, but at least you will get information from my assistant if it is ready. If it is ready, then a Zoom link will be sent and I will read it just like we've done here. Does that sound okay?
Yes. That's fine, my lord. The most
So for now, let's say I will read the ruling at, actually let's make it more certain. I will, let's put the ruling at 2, unless you hear from my assistant otherwise that it's not ready, then we will tell you when it will be ready. But for now, let's plan to come back at 2.
Thank you.
Or I think we have done.
Yes, we are done.
Okay, thank you.
Thank you.
Where was the step? Where was the step?